Welcome to Discovering the Law. My name is Lucy Rivera, and today we have attorney Kevin Henley. He is a former professor of mine, and we are here to discuss some very relevant legal topics. Professor Henley, thanks for joining us today.
I'm happy to be here. Thank you, Lucy.
We appreciate your time, like always, and sharing your wisdom in the law. Professor Henley, tell me, what are some of the important decisions that have been decided lately in the Massachusetts Supreme Judicial Court?
Well, thank you for asking. That's a great question. In January of this year, the SJC handed down a very important case called Cotters against Uber, against the Uber Lyft service. And that case is very important and a very good case for consumers in Massachusetts.
And why is that case very important for consumers in Massachusetts?
Because the court decided that the click wrap contract to arbitrate a dispute was not enforceable against a Massachusetts consumer. Uber's online terms and conditions were not enforceable against a Massachusetts consumer.
And why weren't they enforceable?
The court said that an online contract has to satisfy ordinary principles of contract law, which include knowledge of the terms and assent to those terms. And the Uber's procedure for signing up a new Uber registrant, a user, did not satisfy those requirements.
You said about the principles of contract law. What are those principles?
Well, one of the basic principles of contract law is that it needs to be mutually assented to by all parties to the contract. The contract is only binding if both parties agree. In order for a party to agree, the court said that the parties have to be knowledgeable. They have to know what they're agreeing to. And the court said that the Uber sign-up process did not provide any assurance that the Uber user knew what the terms and conditions were. And therefore, the user of Uber services could not assent, and therefore there couldn't be a binding contract.
Oh, that's very interesting. Why don't you tell us a little bit more about that case?
Well, it's a very important case because these days consumers are buying more and more products online. More and more services are sold online. And every time a consumer purchases a contract or a service online, they are asked to assent to terms and conditions, which they, in most cases, have never read, and which are totally favorable to the vendor and totally unfavorable to the consumer. These are called contracts of adhesion, and they include the Uber contract, for example, in the Cotters case, said that the user indemnifies Uber against any possible claim, and that the user cannot go to court to assert any claim, but has to go to arbitration, binding arbitration. And it specifies what the terms of those arbitration is. It includes limitations of liability that essentially say Uber is not liable for any harm that may the trip may cause to the consumer. So consumers are helpless in the face of these vendor-written contracts, which can be many pages long, and which the consumer really has no meaningful opportunity to review prior to making the purchase.
So in that vein, aren't all these contracts tacitly binding when you open a service or when you apply for a service?
The court was very careful to discriminate between binding online contracts and not binding online contracts. In this particular case, the Massachusetts Supreme Judicial Court said that Uber's procedure that the user had to follow in order to register as a Uber user never actually required the user to look at the terms and conditions. And therefore, and nor was the actions that were required of the consumer unambiguously to express assent to the terms and conditions. So in that case, the court said Uber could easily have satisfied these requirements if it had followed the proper procedure. But since it didn't follow the proper procedure, the user was not bound by the online terms and conditions.
Okay, well that's interesting, but I don't, could you please describe what were the procedures that they were supposed to follow, and how is it that the court found that the contract of adhesion did not follow or wasn't followed with those procedures?
Sure. The court described in detail exactly what steps the new Uber user has to follow in order to register as a Uber user. And there are essentially 3 steps. Step 1 is entering their email address. Step 2 is entering their user profile. And step 3 is entering their payment method.
Okay.
And it's only when they get to step 3, entering the payment method, that there is a little box that appears that says that by signing up for the Uber service, you agree to the terms and conditions, Uber's online terms and conditions.
Right.
And after the consumer enters the payment method, he is then directed to press finished. And that finally registers the consumer as a user of Uber.
Okay, right.
Now, Chris Cotters, the plaintiff in that case, was able to sign up and become an Uber user without ever looking at the terms and conditions. If Chris had pressed the box that around the terms and conditions, the reference to terms and conditions,
yes,
then that would have linked him to another screen, which would have given him a choice between terms and conditions or privacy policy, and he would then have to click on either one of those. And only if he clicked on terms and conditions would he go to yet a third screen and finally actually see the terms and conditions. But there was no requirement, there was nothing on the website that required the user to press that terms and conditions box that would have enabled them to see the terms and conditions. And in fact, the court's opinion indicated that Chris Cotters never actually pressed the terms and conditions and therefore never reviewed them.
And would that be a defense that could be available to all of us, for example, where did we deal this day and age with that kind of contract of adhesion when we applied for a credit card, for instance, or when we sign up for Uber or some other service like that? Where
it could be, although I think probably most online vendors have read the Cotters case and have educated themselves as to exactly what Uber did wrong, and will probably correct that error in their own online procedures. But what it tells us, the lesson of the Cotters case, is that the courts are going to scrutinize very carefully the user interface of these online vendor contracts, and are going to hold the vendors to a very strict standard before it will enforce online terms and conditions against a consumer.
So a couple of follow-ups on that. Please discuss the strict standard that they will now be scrutinized under, but also is that available to all consumers? Would that be something that we can all benefit from when we want to get away from those terms in the contract?
Absolutely. This is a case, a decision of the Supreme Judicial Court of Massachusetts that states the law in Massachusetts. It's the law of online vendor contracts in Massachusetts, and so it's available to any consumer in Massachusetts. And for that reason, it's a very important decision.
And is it available because there is that, I guess, Uber mistake? Would that be something across the spectrum?
Well, I think not. I think, as I mentioned, most online vendors are going to learn from that decision. They're going to correct that mistake.
Which was?
Which was having a registration procedure that did not require the consumer to actually view the terms and conditions.
Okay, great.
But a vendor that corrects that mistake may well commit other mistakes. And so it behooves every consumer to get expert counsel to look very carefully at exactly what is the registration process and what is the interface, the user interface that the vendor is claiming supports the enforcement of the contract, because there may well be other errors, and the courts are going to scrutinize it very carefully. And
so when you say that, what do you mean?
Well, what I mean is that if for example, a consumer purchases a travel-related service online from an online vendor and is injured as a result of that service, there's something goes wrong and there's an injury, the consumer should not conclude, oh, well, the terms and conditions say that the vendor will not be liable for any injury that is caused to a user. That's not the end of the story. That online term and condition may or may not be valid depending on whether the vendor has followed proper procedures or not. And so if a user, a consumer, a Massachusetts resident is injured by a product or a service that the consumer purchases online and complains to the vendor, and the vendor says, oh no, we're not liable because look at our online terms and conditions. We have a limitation of liability and an indemnification clause and a forum selection clause and an arbitration clause that absolutely protects us from any liability for your injury whatsoever. Some consumers would be deterred and they would go, oh, well, I guess we're out of luck. But that's not the right procedure. What the person should do is should get expert counsel and review the case law, the Cowders case in particular, and there's some other cases on point as well, and then should very carefully review the user interface that the vendor utilizes to see whether there are any defects that would cause all of those protective provisions to be unenforceable against the consumer.
Oh, well, that is a fascinating topic, because people now can have a defense from all those contracts that bind them.
Well, I'm only talking about consumers who have a legitimate, complaint, who have been injured by a service or a product that they buy online.
In this case, for example, Chris was able to abide from that defense because he did not follow the procedures. But for the regular consumer out there, how would we know what the procedures are and what are the defects that we can claim?
Well, this is a good reason to consult a consumer protection lawyer. Mm-hmm. There are lawyers who specialize in consumer protection, and particularly consumer protection with vis-a-vis online vendor contracts, and that's why it's a good idea to check with the lawyer, because oftentimes the lawyer's fees will be paid for by the defendant if the lawsuit is successful.
Okay. Well, we have 10 minutes left.
Sure.
And during this time, would you tell us more or less, not only in your case, but in general, you mentioned that there are clauses that these vendors abide by, the arbitration clause, and now, how can they is that legal for them to put all these clauses in their contracts?
That's a great question. In fact, these vendors are often national vendors, and they sell not just in Massachusetts, but in other states as well. But they will have only one set of terms and conditions, online terms and conditions. And Massachusetts law is different from the laws of other states with respect to what protective provisions are permitted in an online contract. So, for example, in Massachusetts, it is not lawful, it's not permitted for a vendor to disclaim any liability for any future injuries, any future injuries that that vendor's product or service may cause to the user. And yet, if you look at the standard terms and conditions, online terms and conditions of these national vendors, they all eliminate liability. They all preclude vendor liability for injuries that have, not only injuries that have occurred already, but injuries occur in the future, which is impermissible in Massachusetts. So the answer to your question is no. Many of the terms and conditions that are included in these standard contracts of adhesion are not enforceable in Massachusetts. And many of them have yet to be tested. And they will only be tested if they're brought to the attention of a court, and a court can take a look at them and apply established principles of law to determine whether or not they're enforceable.
How could we enforce that if this is just Massachusetts that's not permitting them, but the other states, you said they're permitting?
Some are more pro-consumer than others. You know, some states are very protective of their residents, and other states are less protective of their residents.
Right.
And so it really depends. It's state by state comparison. But you know, here in Massachusetts, a consumer should consult Massachusetts counsel, and they will review the Massachusetts case law to determine whether or not these protective provisions are enforceable here in Massachusetts.
And well, to just follow up on that, we're in Massachusetts and that we feel protected by those laws. But if someone is a resident, a visitor of another state, and comes to Massachusetts, or the company is, I don't know if Uber is a Massachusetts company or any other company, how could we reconcile those different jurisdictions?
That's another great question, Lucy. Now I know why you were such a good student.
Thank you.
That raises an interesting question, a choice of law. And typically these terms and conditions will contain a choice of law that will say that this contract between us and the consumer is governed by the law of state X.
Oh, wonderful.
And typically state X is going to be the state that is least protective of consumers and most pro-business. But the Massachusetts courts will not enforce such a contractual legal governing law clause unless they're reasonable. And in many cases, the choice of state X law to govern the contract is just not reasonable because the transaction occurs here, the consumer resides here, and the injury may have occurred here. So what does state X have to do with it?
Right. In case of Uber, but in terms of a credit card company that has those kind of clauses, arbitration clauses, then I guess that's a different scenario. Or
well, credit card law is largely federal under Regulation E of the Federal Reserve Board. Now the Consumer Protection Bureau, the terms and conditions of the electronic payment contract are governed by Regulation E. But Regulation E does not preempt protective state law. And just because Regulation E does not provide automatic liability to the consumer, that's not a reason to stop looking. The lawyer, the consumer who has been injured by some transaction involving their credit card should also look at Massachusetts law to see whether or not there's a cause of action under Massachusetts law.
And in this case, do you feel that maybe the federal law gives less protections than the state law? And is there going to be a conflict of laws, or will that?
That's an interesting question. In some respects, yes, federal law is more protective of the vendor, of the bank, issuer of the credit card than state law would be. But the general principle of Regulation E, which governs, electronic payment methods, is that it does not preempt more protective state law. So generally speaking, there shouldn't be such a conflict.
Good. Well, we have 5 minutes left. Do you want to give us some last-minute thoughts, or did you want to say
I'd like
something?
to mention one thing. There's another case that's interesting that's come across my desk, and that has to do with the so-called bank error in your favor case, where
we only have 5 minutes.
Where there's if you have a bank account and then suddenly what appears on your statement is a credit for a sum of money that you don't know why that's on your statement.
Interesting.
Well, it's up to you. If you have reason to believe that you've received money that doesn't belong to you on your bank statement, it's up to you to notify the bank and to inquire, why did I receive this money?
Interesting.
Because if you don't, and that money belongs to someone else, should have been credited to someone else, then you could be criminally liable for larceny, for not turning over those funds. So never trust, a large windfall that appears on your bank statement. Never just accept it without asking questions.
That's great advice for everyone out there, because on one hand, it is really not consumers' fault that the bank made an error, and the consumer may say, "Oh," innocently, maybe seeing this or not noticing and just keep withdrawing money.
True.
Not noticing that they're ever looking at their statement. Although a little incredulous, but there are cases where people don't follow it.
It's difficult to look at your bank statement these days because, typically you'll get a email notification that your bank statement is available online.
Right.
You'll have to click on the link. That will just take you to the bank.
Right.
Then you have to figure out where on the bank's website do you have to click in order to get to bank statements, and that's once you get there, then you'll have to click to indicate which account it is. It's quite a burdensome process to actually look at your bank statements these days.
And quite punitive to the consumer, I would say. But Professor Handley, actually, I'm being told that we wrap it up. But this is it's a fascinating topic, and it's interesting how it opens a whole slew of liability on innocent people who may not even realize they have an additional $5,000 or one. And if you don't report it, then the consumer is criminally liable. That's interesting legislation.
It could well be. Well, it's not actually, it's just a variation on the theme of theft. For example, if you're walking on the sidewalk and you saw someone drop a $20 bill in front of you, and you picked it up and you put it in your pocket and you didn't alert the person, that would be theft under any definition of theft. But if you walk along the sidewalk, there's nobody around, and you find a $20 bill, put it in your pocket and spend it as soon as possible.
All right, well, in the 30 seconds we have left, I want to thank you, Professor Handley, for being here today. I appreciate your time and donating this time to us to learn about what you know and your experience. And for everyone watching, I hope you learned a lot from Professor Kevin Handley from BU Law School. And my name is Lucy Rivera. I'm an attorney. And you can watch this episode at www.discoveringthelaw.com. And thank you so much for watching. I hope you keep watching the show.